Okay, wonderful. Welcome, everyone. Just for your notice, the event is being recorded. But I'm so grateful that you could all join us for this second event in the series of talks that the forum is hosting. And the title of the series is Fundamental Rights for Non-Humans. And today we are joined by two incredible speakers. We are joined by Professor Patricia Wiater, who holds the chair for public law, public international law, and human rights at the University of Erlangen in Germany, and is the member of the Center for Human Rights at the same institute. She has a French-German doctorate in law with a thesis on European human rights law and cultural pluralism from the University of Strasbourg and the University of Leipzig. And she also has a doctorate in political sciences from the University of Freiburg. In her current research, she deals with the overall phenomenon of human rights governance of non-human subjects, such as corporations, nature, animals, and AI. Today, she will be speaking on a paper entitled Exploring the Boundaries of Immersive Anthropocentric Human Rights Protection, a Political Justification of Rights of Nature. Professor Wiater will be speaking for about 20 minutes. After her, we'll be hearing from my long-time friend and colleague, Dr. Visa Kurki, who is Associate Professor of Jurisprudence at the University of Helsinki, where he is also Director of the Helsinki Animal Law Center. He is the Vice President of both the Finnish Legal Philosophy Society and the Finnish Society for Animal Rights Law. He has a PhD from the Faculty of Law, University of Cambridge, and he was the recipient of the York Prize and of the Salge Medal for his doctoral thesis, which he published as, I think it's fair to say, the well-known book, A Theory of Legal Personhood, which Oxford University Press published in 2019. His research focus is on legal theory, animal law, and social ontology. So, as I said at the beginning, we are going to hear from Patricia for about 20 minutes, and then from Visa for about 15 minutes. Following that, Patricia may respond for up to 5 minutes to Visa's comments. And after that, we will have a Q&A. I'm now going to share in the chat if I can, the notes that Patricia has prepared for today is a handout. So I'm going to share that in a moment. And so you can refer to that while Patricia is speaking. Okay, this should be loading. If you have any issues accessing the handout, please just let us know. Okay, so I leave the floor.
Sorry, John. You've just sent it to me directly.
Oh, sorry. Let me send it to everyone in the meeting. Please give me a second. Okay. Hopefully everyone should now be about to receive this. Okay, fantastic. So it's my great pleasure to leave the floor to Patricia. Thank you very much.
Thank you, John, for this very nice introduction. Yeah, in recent years, the Inter-American Court of Human Rights provided very important thought for human rights scholars who are concerned with topics like fighting biodiversity loss, species extinction, climate change, and the degradation of the world's ecosystems. What happened? In the famous advisory opinion the court gave in 2017 on the topic of the environment and human rights, as well as in a judgment from 2020, the court stated that the human right to a healthy environment includes an autonomous right that protects nature as such, as an independent subject. So the court expanded human rights protection to components of the environment, such as forests, rivers, and oceans, as legal interests in themselves, even in cases where a threat to individuals is not certain or proven. This approach to integrating rights of nature into an existing human rights system and its judicial enforcement mechanism is inspiring. And it seems to be promising because international environmental agreements, such as the Paris Climate Agreements, do not have a comparable hard enforcement mechanism. The approach is particularly inspiring for European human rights scholars and European human rights practice. Currently, the European Convention on Human Rights does not include a human right to a healthy environment. However, within the Council of Europe, the political process of incorporating such a right into the European human rights system is underway. So with a view to the future of European human rights, we must discuss quite crucial questions. Could the inter-American approach of integrating non-human protection concerns into the human right to a healthy environment work in Europe? And how can such an expansion of human rights subjecthood be justified, both from the perspective of human rights theory and from the perspective of human rights doctrine? I would say that from a bird's eye perspective, the rights of nature discourse offers us two central arguments for justification. The first is a morally grounded argument. It goes as follows. Granting autonomous legal rights to subjects of nature is defined as an essential condition to protect the intrinsic value of nature. So intrinsic value is the core argument. It means acknowledging that nature's value is not to be equated with the utility for present or future generations, but it is beyond human interest. The second argument is that acknowledging original rights to nature and this intrinsic value is a decisive tool in managing the global ecological crisis and climate change. And my discussant Visa identifies a symbolic rationale behind the first argument and an instrumental rationale behind the second. If detached from ethnic or religious origins, the symbolic, morally grounded reference to nature's intrinsic value does not convince me. I think that much more convincing is the political critique of anthropocentrism inherent in the rights of nature claims. So in the following, I will briefly explain why I believe that the intrinsic value argument is not suitable for justifying a rights-based approach to nature conservation. And this will allow me to discuss contours of a legal political justification of this rights-based approach. When it comes to justifying rights of nature as an integral part of human rights, my position is the following. The political instrumental call for rights of nature is based on a governance assumption. This governance assumption means that the traditional anthropocentric human rights approach cannot result in a similar level of protection of nature as the rights of nature approach would. This confronts us with the task of exploring the doctrinal potential and the limits of anthropocentric human rights protection. I will do so by referring to the environment-related case law of the European Court of Human Rights, which traditionally stands for strong anthropocentric human rights protection. My analysis will reveal that the political grounds for integrating rights of nature into human rights protection are inextricably linked to the ecological failure of the state. Compared to morally grounded rights of nature, this justification must be considered in a differentiated way with regard to the extent of state failure. Let's look at the shortcomings of the intrinsic value argument. Reference to the intrinsic value is often made by proponents of rights of nature. To give an early and very prominent example, I would like to refer to Christopher Stone. As we all know, 50 years ago, he was one of the first seriously proposing, I'm quoting, that we give legal rights to forests, oceans, rivers, and other so-called natural objects in the environment, indeed to the natural environment as a whole. End of the quotation. He embedded this claim in the broader context on conferring rights onto some new entity, as it was practiced with regards to women or slaves in the past. And he said, there will be resistance to giving the thing rights until it can be seen and valued for itself. Yet, it is hard to see it and value it for itself until we can bring ourselves to give it rights. Referring to an intrinsic value is a very familiar concept for moral human rights thinking. To give 2 examples, for James Griffin, human agency and autonomy forms the necessary substantive account to the value grounding human rights. For Pablo G. Labert, by contrast, human dignity is the expression of the inherent non-instrumental normative status of human persons that serves as the foundation of moral human rights. We see that both accounts build on clarifying relevant properties of the human being. Agency for the one, dignity for the other, in order to specify the human value. So both follow the formula in order to deduce moral human rights from nature and human nature. We must be able to specify what attracts special protection in human nature. Put in other words, what human beings are like. And here I see a crucial problem with justifying a concrete set of rights of nature by reference to an intrinsic value. We do learn from rights of nature proponents that natural subjects are intrinsically valuable, but we do not really know and always know by virtue of what specific properties. If we consider the diversity of possible subjects included under the concept of nature, the problem is that we can hardly determine what nature is like. Following non-anthropocentric approaches in environmental ethics, we can roughly distinguish between the view that animals possess intrinsic value, zoocentrism, the view that all living organisms possess intrinsic value, biocentrism, and the view that all forms of life, including organisms and ecological collectives such as populations, species, and ecosystems, possess intrinsic value, ecocentrism. Last week, John illustrated that it is quite easy to identify relevant properties of animals. Animals are sentient beings and aware of experiencing the value of their own welfare. Ecosystems, on the other hand, have no such obvious self-explanatory properties, since these are in constant flux as populations move through them and conditions change. Some authors come to the conclusion the more indistinct, incoherent, and rapidly changing and arbitrarily defined ecosystems or communities seem to be, the more difficult certain kind of ecocentric ethics become to maintain, especially those that depend on the idea of systems having a good or interest that can be set back or damaged. Rights are not even mentioned in this context. This leads me to contours of my political justification. The vagueness of a value-based justification of rights of nature as legal rights allows me to explain my understanding of a political justification. We all know that ecosystems play a crucial role in fighting climate change. They are impacted through changes in mean conditions and in climate variability, and at the same time relevant to assist in the mitigation of and adaptation to climate change. So, as rights of nature proponents indicate, there might be strong reasons to improve the level of protection of ecosystems by means of a human rights approach. However, the interest in mobilizing the instrument of human rights protection for this purpose cannot be derived from the characteristics of the ecosystem, but it is defined by humans themselves. If there are protection gaps in anthropocentric human rights protection that only a rights of nature approach could fill, doing so would be a human interest. In this vein, it was stated that instead of, I'm quoting, representing the rights of nature as grounded in some principle of meta law and recognition thereof as mere discovery and affirmation of a priori rights, any extension of legal rights to nature is informed by a conscious political choice, a reflection of human value judgments. That was said by Günther Handel. So accepting this does not make the possible legal foundation of rights of nature bad or less honorable. The decision to integrate corporations into the European human rights system is obviously also grounded in human interests, since there is no moral duty to do so. This leads to the challenge to identify the existing potential and the limits of the so-called greening of anthropocentric human rights protection. In doing so, I will first have to clarify that anthropocentrism is not a static concept. It includes broad understandings like that of immersive or weak anthropocentrism. Immersive anthropocentrism still considers nature as an object and relates nature's protection to the interests of human beings. However, in contrast to the human first and only approach of extractive or strong anthropocentrism, the legal paradigm of immersive anthropocentrism acknowledges the interconnectedness and interdependence of human beings and nature. Understanding human beings as interlinked and interdependent participants with duties to protect and conserve all elements of nature, whether or not they have known benefits or current economic utility, defines, for Dina Shelton, a core of anthropocentric purpose. So I was wondering, to what extent has the potential of immersive anthropocentrism already been exhausted by the Strasbourg Court? And this question leads us into the details of human rights doctrine. Considering the existing environmental case law of the European Court of Human Rights, as well as legal arguments put forward in ongoing climate change applications before the court, we gain two important insights. The first is that the potential of anthropocentric human rights protection to intensify the fight against climate and the climate and environmental crisis is far from exhausted. In a very impressive study, Natalia Kobilatz recently demonstrated in detail how the European Court of Human Rights Fair Balance Review could be mobilized to establish and strengthen ecological minimum standards in the European human rights system. The pending climate change applications draw attention to further doctrinal avenues that are in theory open to link European human rights more closely with global nature conservation concerns. To mention just some of the potential gateways, an immersive reading of anthropocentric human rights could be enhanced by opening and expanding the victim requirement, not only to NGOs as applicants, but also by accepting future generations as potential victims, thereby taking greater account of the principle of intergenerational equity. This could also happen by an intensified level of scrutiny in environmental claims on the part of the court, which would then go hand in hand with a reduced margin of appreciation on the part of the respondent states. Moreover, it could happen by strengthening the positive obligations states have to fulfill in order to protect their citizens against transnational large-scale threats, such as climate change. Looking at these possible gateways for greening European human rights, we gain a second important insight. The case scenarios underlying these doctrinal avenues towards strengthening immersive anthropocentric human rights protection are all characterized by a concurrence of the potential interests of nature and the expressed interest of human applicants. To give a concrete example, in the pending Klimaseniorinnen case, the applicants claim that Switzerland is failing to fulfill its positive obligations under the European Convention, since the state is not doing everything in its power to prevent a global temperature rise of more than 1.5 degrees Celsius. In this case, the expressed interest of the applicants, that is elderly women, in not suffering any adverse health effects due to climate change concur with the potential interest of natural subjects that are also negatively affected by heat waves, for example, ecosystems or animals. So we learn that if the impairment of a natural entity, be it a concrete one such as a forest or a global one like the climate system, can be legally conceptualized as a concurrent impairment of humans, and as an infringement of their human rights, immersive anthropocentric human rights protection opens powerful means to respond to the protection needs of nature. In the case of such a concurrence of interest, the need for protection of nature is incorporated in the need for human protection. Hence, according to my previously defined standard for justifying rights of nature, there is no political rationale for independent rights of nature in this scenario. This finding points to the limits of anthropocentric human rights protection. An obvious gap in the protection of nature exists where there is no such concurrence, either because there are, first scenario, no human beings who are co-affected and who can assert their human rights protection on behalf of nature. Imagine the following facts. A state issues permits for slash and burn clearing of a forest area, but no humans live in the immediate area of the forest. Or because, second scenario, the protection interests of the natural subject go beyond remedying damage for the benefit of humans. To illustrate this second scenario, again, at the example of the Inter-American Court of Human Rights. In the case of the indigenous communities of the Laka Honat, the court followed from the violation of the autonomous right to a healthy environment that Argentina was not only obliged to realize typical measures of redress that aim at the restitution of ancestral property and the improvement of the quality of life of the human applicants, the applicant communities. In addition, the court ordered Argentina to, I'm quoting, combat illegal logging in general. So imposing obligations on states to protect nature that go beyond the remediation of the human victim is difficult to reconcile with anthropocentric human rights protection. In this constellation, the claim for human independent protection and restoration of the natural subject remains relevant. This raises the crucial question of whether the legal doctrine of anthropocentric human rights protection has any potential to integrate and give effect to autonomous protection concerns of nature. And again, I looked at the case law of the European Court of Human Rights and found that this case law indeed reveals that this potential exists. Autonomous protection concerns of natural entities do become apparent in the doctrine of human rights control when states invoke the protection of ecological interests as a legitimate aim in order to justify interferences with conflicting human rights. In this scenario, protection needs of natural entities do not play a role as enforceable rights or human rights. Rather, they come into play as a matter of proportionality review when a state has implemented ecological protection concerns in its natural legal system, and when applicants invoke before the European Court of Human Rights that these national measures violate their European human rights. For example, in the case of Maczynski versus Poland, the applicant claimed a violation of his property rights, because a local development plan that served the conservation of nature prohibited him from building on his farmland. In this case, the court in Strasbourg accepted that conservation of nature forms a legitimate aim of the state that allows restricting human rights. It stated that, and I'm quoting, "In today's society, the protection of the environment is an increasingly important consideration. It has become a cause that arouses the constant and sustained interest of the public and consequently of the public authorities." The court has stressed this point a number of times with regard to the protection of the countryside and forests, and more recently with regard to the protection of the natural state of the seashore, coastal areas, and in particular beaches. End of the quotation. So we see that in this case scenario, anthropocentric human rights protection also opens up the possibility of allowing ecological concerns to take full effect in human rights proceedings on the level of human rights, and to powerfully assert them, for example, against economic interests. At the same time, the fact that human independent, so autonomous ecological interests are nothing more than a legitimate interest that states can invoke or cannot invoke demonstrates the fragility of this legal foundation. And this finally points to the grounds of a political justification of rights of nature. If states do not implement effective ecological protection in their domestic legal system in line with rights of nature claims, these do not reach the Strasbourg Court, and they cannot reach the Strasbourg Court. In constellations where there is no concurrence of interest of nature and humans, the political justification of rights of nature at the level of human rights is based on the ecological failure of the state. Compared to morally based rights of nature, as I said in the beginning, this justification must be considered in a differentiated way, as it depends on the extent of state failure to combat biodiversity loss, climate change, and the destruction of the world's ecosystems. So this means that the claim to recognize an autonomous meaning of the right to a healthy environment in future human rights proceedings before the court in Strasbourg may be justified for some states that have a very poor record in ecological matters, but not for others. Thank you very much, and I am happy to listen to Visa.
Thank you very much, Patricia. Visa, you can now take the floor for 15 minutes.
I cannot hear Visa.
Yeah, I think you're muted. No. No, we cannot hear you still. Can you try to talk just from the microphone of your laptop or computer? Okay. Okay, thank you everyone for your patience. We're just having some technical issues.
The Zoom nightmare.
Yeah, we are hopeful to be able to restart in a minute or so. For those that joined after I shared Patricia's handout, perhaps it's the case that I will try to send the handout again in case you want to refer to it during the Q&A. Hoping that Visa can join us again. So I'm going to send the handout. And while we wait for Visa to rejoin, I would like to remind you that this talk is being recorded, and that
hello, can you hear me now?
We can hear you, yes. That's
great. I really don't know what happened because we tried the microphone before the presentation started. Everything was fine.
Yes, that's fine. Now we can hear you. I'm gonna spotlight.
Very sorry about that.
No problem. So you have about 15 or so minutes to respond to Patricia, and then Patricia will be able to talk to respond to your points for 5 minutes afterwards. Thank you, Visa.
Great. So thanks so much for this very interesting presentation, and also for the paper that I got to read, and thanks to John for organizing this lovely event. So as a sort of background, I got this paper a couple of months ago, and it was maybe a bit of in a draft stage, and I think some of the issues that I thought I'd bring up were actually, I think, covered during this presentation. So, but I've been sort of thinking on my feet about what to say. Anyway, the way I sort of understood this presentation, and feel free to correct me if I'm wrong, is that you're quite skeptical about rights of nature, and in terms of why you're skeptical is, first of all, that you find the sort of intrinsic value argument for rights of nature, which posits that nature, some parts of nature or ecosystems or something, have intrinsic value and therefore should have rights, and you're skeptical about what exactly this argument means. And then you discovered or discussed the sort of a political argument for rights of nature, which is more like a practical argument that we need rights of nature to achieve some important goals. And you argue that that this argument fails as well, at least if I understand correctly, in the context of the European Convention on Human Rights. So I did enjoy this paper, and I'm not sure I think I broadly maybe agree with the approach, but I thought I'd still bring up some critical things. Well, some are more critical, and some are more just discussion points. So first of all, I think especially this was much clearer, I think, in the presentation than in the paper that I got to read. But in the paper, there seemed to be this sort of a switch back and forth from rights of nature in general to rights of nature in the context of human rights, because I think these don't, of course, like they are related, but I think occasionally they might, the way rights of nature work specifically in the context of human rights might need specification. So some of the classic work in rights of nature, like Stone, for instance, was not really in the context of human rights, but rather in the context of sort of domestic law. I think this was a bit clearer in the presentation. But I mean, for instance, like as you brought up in the talk, human rights are founded on dignity, and one might want to argue maybe that if we extend rights of nature to if we extend human rights to nature, then we might need an argument for the dignity of nature potentially, or then we need some other bases for rights of sort of human rights of nature. And I agree that that in the context of human rights, especially, there are a number of different. So if we think of rights of nature sort of very practically, so they are meant to solve some tools, or so they're meant to be tools to solve some very practical problems. I think in the context of the US and where Stone was writing, so I think one of the main issues was standing. So who can sue in order to protect nature? I think this particular problem doesn't necessarily even apply to some continental jurisdictions, which are much more flexibility with regard to standing. I know that I think in Germany, for instance, but also in Finland, for instance, and environmental organizations can actually challenge in court various official decisions regarding environmental permits and so on, without having to sort of pretend that their rights are in any way threatened. So I think this kind of contextual assessment of where there is sort of an instrumental justification of the rights of nature is quite important. Now, as regards to sort of the intrinsic value argument that you discuss, and I have to say that I've also been quite skeptical about the sort of intrinsic value of nature, but there were some things I was wondering. First of all, the whole notion of the intrinsic value is extremely unclear, and I become less and less convinced that using the term is useful, because especially I think lawyers use the term very sort of in a very fuzzy and unclear manner, and it's often very unclear what exactly they mean by it. First of all, I mean, in this broad sense of the term, we can talk about, for instance, music have an intrinsic value, or art, or paintings, or and so on. And especially in this broad sense of the term, it's not obvious that merely something having intrinsic value means that it should have rights. It's not. I don't think music should have rights, for instance, or paintings, or so on. So this, in this broad sense, it's because I think sometimes when people talk about the intrinsic value of nature, they mean something similar to if we said music has intrinsic value. They mean something like that. Nature is intrinsic valuable to me in a way. It's an important part of sort of my understanding of life worth living, or something like that. That there is nature out there. So that's like one issue that I have with intrinsic value in general. However, on the other hand, I think the way the discussion has been moving is that I think many of the proponents of rights of nature have maybe been moving away a little bit from this sort of traditional way these issues are approached. I think Joshua Gellers has this distinction between, is it properties based and what's the other one? Is it maybe relational accounts of rights of nature or rights more generally? And I think you're clearly in the sort of properties camp, and I think I'm mostly as well. But the other camp would rather, in a way, reject looking for properties that give you intrinsic value. Rather, they would sort of seek to understand nature as this sort of an interconnected whole, where it's not exactly the properties of any one being that gives its intrinsic value or rights or whatever, but rather what part it plays in the overall sort of system, in the overall harmony, if you want to call it, or the overall interdependent system. I think one sort of important example of this philosophy with regard to rights of nature is something called earth jurisprudence. I'm not personally always convinced by the arguments of people discussing or people proponing these views, but I think it would still be good to somehow mention this in your paper, to actually take up the arguments of this sort of a movement. Also, when you discuss sort of the vagueness of rights of nature and the sort of idea of intrinsic value, it might be, I think, maybe the most concrete example. I'm not saying it has its problems, but still the maybe most developed case of rights of nature is the Estrellita case from Ecuador, where a monkey basically was derived. So they used the sort of very general rights of nature provision of the Constitution to derive this sort of rights for individual animals. So that might be sort of a more concrete example of what this approach might mean. I think another issue, so in a way you've been arguing that the sort of instrumentalist argument or rationale for rights of nature fails, at least in the context of the European, well, okay, not that extreme, but that, okay. So maybe it doesn't fail, but that actually in many cases we don't need it to achieve some of the goals. Would that be more correct maybe? Well, you can correct me soon. In any case, I was just wondering whether this sort of so I mean, at least many people arguing for rights of nature think that we should sort of revamp our whole thinking about rights. We are currently too individualistic, too atomistic, and sort of perpetuating a capitalist system that's sort of the reason why we're in the state that we're in. And the rights of nature, especially understood in this sort of relational sense, might sort of provide tools for getting out of this situation. So it would be interesting to hear what you have to say about that sort of a more systemic argument for rights of nature. I had some more specific comments about the paper that you did not touch in the presentation. I think some of these might be a bit boring for the audience, but maybe I'll mention a couple.
You can also send me your notes, because this is very important for me too.
Sure. Yeah, I can do that. Some things that I might want to maybe mention here. I mean, I didn't have too many comments, but I had a couple. First of all, you mentioned somewhere in the paper that the sort of rights of nature approach would mean dismantling the subject-object binary of law. I'm maybe a bit skeptical. I mean, that might be true, but often I think that's phrase that's been thrown around a bit too easily, because I'm just wondering if you just reposition the subjects and objects, that we will get new subjects. It doesn't seem to me that it would dismantle it necessarily. it might do it if we really go all in, you know, and we see everything as sort of a relational. In some sense, everything is a subject and so on. But I wonder how many people actually are proponing that. Then just another sort of a minor thing is you mentioned the case of this phrase "in dubio pro clima et natura," which is like, in case of doubt, act in or judge in favor of the climate and the nature. I'm just wondering, that sounds like actually a very weak principle in many ways. Whereas in the paper it's presented as something stronger, but to me it sounds like if we have an unclear case, then we can pick the alternative that's better for nature and climate. And to me that sounds actually quite weak. So that's something I'd be interested in hearing your thoughts. And one final point, in the paper you write that promising candidates as rights bearers are animals whose potential capacity to hold rights was originally conceived in the context of moral rights. I think this is sort of the Anglo-American story, and of course Anglo-American people tend to ignore what happened on the European continent, but actually there are like a lot of well, let's not say a lot of, but there have definitely been like legal scholars actually on the continent discussing animal rights even before the sort of Anglo-American first wave animal ethics. So some of these examples are a bit obscure, like Carl Christian Friedrich Krause was a German philosopher who actually discussed this in his philosophy of rights. Alf Ross actually brought up the idea of animal rights, in the great Danish legal philosopher brought up the idea of animal rights in some of his work, and there are some other examples of like legal scholars discussing this idea. So this was just like, I thought it might be interesting for the audience, so that's why I mentioned it here. But anyway, I think I'm done with my comments and I look forward to the discussion. Thank you.
Thank you. Thank you so much, Wiater, for your comments. And I would invite Patricia, if she has 5 minutes or so, to reactions to Wiater's point, and then we'll open up a Q&A. For the audience, please, after the response by Patricia, we will stop recording. And so you can either feel free to send a message in the chat, a question or a comment in the chat, or you can also signal that you want to be videoed, and you can ask your question in person, so to speak. Okay, Patricia, please take the floor. Thank you.
Thank you so much. So, Wiater, as you said, I clarified a lot when I prepared this presentation. For example, that I'm really now specifically interested in integrating rights of nature concerns into human rights protection systems, because I see that there's a powerful tool and powerful enforcement mechanisms, especially when we look at European human rights protection. So this is what interests me. Also, the African system does have a strong judicial enforcement mechanism with the Commission and the African Court. So the idea of integrating rights of nature concerns into this human rights to a healthy environment is very inspiring. So that was really specified, and you did not know it. So I surprised you with all these doctrinal details about the case law of the European Court of Human Rights, and I'm sorry that I did so. As you said, I'm skeptical about this intrinsic value argument, but I'm less skeptical with regards to this, what you call practical argument. So maybe this was really a misunderstanding. What I did is to somehow shift the rights of nature claim into a claim to push the boundaries of anthropocentric human rights protection, to check how much can we gain by broadening our understanding of anthropocentrism. And as I said, we have different readings of anthropocentric human rights protection, and there is this idea of an immersive anthropocentric human rights protection that allows a much broader understanding of anthropocentrism, and that allows, for example, looking at future generation and not only the one who is already negatively affected by pollution, for example, air pollution, but let's look at how will this affect future generations, and by all the doctrinal aspects I mentioned and you have on the handout. And what I then did in a second step is to find out, well, what are the scenarios where we reached really a lot by protecting human beings? And that was my concurrence scenario. That's where I found out, okay, in cases of concurrent interest, we have a human being speaking in favor of natural conservation concerns, we can gain a lot. And then I asked as a second question, but what kind of case scenarios cannot be tackled because we do not have this concurrence of interest? And I found out, well, there are two very important scenarios we cannot tackle by means of traditional or even the immersive anthropocentric human rights protection. First scenario is there is no human being who is affected. We have a forest, but no one is living there. A second scenario is, well, what we need to do goes beyond remediation of a human being. So there are potential case scenarios where even immersive anthropocentric human rights protection cannot really help us. And then I looked again at the case law of the court in Strasbourg and tried to find out, well, is there still any kind of doctrinal way or tool, instrument to protect those type of case scenarios? And indeed there is, because if we have a state who does all this, protects natural conservation or acts in favor of natural conservation, and then infringes property rights of a human being, can say and stand before the court in Strasbourg and justify these actions by saying, well, this is a legitimate aim. Protection nature is a legitimate aim which justifies interferences with, for example, property rights. But then again, and this is the political foundation, and I think here we are to finally look at who is responsible, the state within the domestic sphere, to do effective nature conservation. And there is the political ground for rights of nature. So I do see, in a scenario where we will have a European right to a healthy environment, I do see claims, human rights claims, based on autonomous protection concerns of nature before the court in Strasbourg. This would make necessary that the court broadens the standing requirements, because right now NGOs cannot lodge applications before this court in Strasbourg. But I do see this scenario that in cases of a complete state failure, or of the failure of the state to effectively implement environmental protection, nature protection, there is this autonomous dimension of the right to a healthy environment. But only in this scenario, not in the concurrence scenario. So this was the distinction I made. So I'm skeptical to some extent, because what I say is, let's push the boundaries of anthropocentric human rights protection as far as we can. And if we reach the limits, then we do have a political ground for rights of nature. So this is maybe what was a little bit rushed through during my presentation, and I'm happy that you asked. I think I do agree to most of the other aspects you mentioned. With regards to the capitalist system, I think this case, I was just mentioning that we do have cases where ecological concerns raised by states can limit the scope of property rights, for example, is a good example that this can already happen. So the system allows it. We don't have an power of always property rights, always economic interest versus subordinated ecological interests. There are ways to have this superiority of ecological concerns. And I think I exhausted my 5 minutes, but that was important to clarify that I am skeptical, but not completely. I do see political grounds to justify this.
That was very helpful, thank you.
And I'm happy to get your notes, all your important notes and comments and authors you mentioned.
Okay, thank you very much, Patricia, and of course, thank you very much, Visa, for your comments. And I think I would welcome virtual rounds of applause for our speakers, but I'm sure they're there. And I will ask Ghosh to stop the recording so that we can go into the Q&A.